The matter before the court is Penobscot 2466, Greenwood versus Lilliav. Okay. I see counsel are present, and if counsel who will be arguing the case would identify themselves by saying their names for the record, together with the parties they represent, starting with the appellant.
Charles King, Your Honor, on behalf of the appellant, Donald Greenwood.
You?
Edward Gould for the appellees, Dr. Lilliav, Eastern Maine Medical Center, and Eastern Maine Healthcare.
Thank you.
Thank you.
We are being streamed live on the web, and have we gotten that camera a little bit in focus? Okay. I kept seeing it too, and it was like, that's really out of focus for counsel. And if counsel, if you're ready to proceed, Attorney King, we're happy to hear your arguments.
Thank you, Your Honors, and may it please the court. This case presents an opportunity for the court to clarify and re-emphasize the law on third-party beneficiaries. As stated by the court, the controlling law on this issue for more than 30 years has come from Section 302 of the Restatement Second of Contracts. The trial court here had to determine whether the tort defendants in this case have a third-party enforceable right in my client's workers' comp settlement with his comp insurer. But we're here today because the trial court did not follow Section 302 to make that determination. Instead, the trial court mistakenly followed the outdated holding in Steves v. Irwin. This reliance on Steves instead of Section 302 caused three critical errors. Number one, it was wrong on the law. Steves is incompatible with Section 302 because they differ both in burden of proof and on the contractual parties they focus on. Here, Steves had the jury determine if the contract showed that my client intended to release the defendants. But under Section 302, the jury would have had to determine whether the contract clearly and definitely showed that the comp insurer intended to release the defendants. This focus on the wrong party's intent and a lower burden of proof means that the defendants did not meet their burden of proof on the release issue as a matter of law. Second, Steves is wrong on the evidence because it is contrary to the collateral source rule. Here, it explicitly invited the jury to consider whether a collateral comp settlement fully compensated my client for his tort damages. Tort damages, by the way, that same jury had just found the defendants liable for in the first phase of the trial. Finally, Steves is wrong on policy because it's contrary to the workers' comp lien framework. Under the trial court's reasoning, third-party tortfeasors like the defendant can now burden workers' comp insurers with damages that the tortfeasors have already been adjudged liable for. And if this court affirms, the workers' comp system is at risk of becoming stymied by hesitant comp insurers and claimants who are worried that a poorly written settlement agreement could cost them their statutory lien on that recovery. Now, the relief the appellant seeks is the simplest way for the court to resolve the issue. We ask that you overrule Steves and re-emphasize that Section 302 remains the controlling law on third-party beneficiaries in all cases, including workers' comp settlements. We ask that you hold as a matter of law that the settlement documents here did not evidence a clear and definite intent to create a third-party beneficiary. We ask that you vacate the judgments of the trial court, and we ask that you remand for a new trial consistent with that opinion. And with that, Your Honors, I'm happy to answer any questions the court may have.
In this case, in phase 2 of the trial, you didn't put in any evidence of the employer's or the employer insurer's intent. Is that correct?
That's correct, Your Honor.
Isn't that, I mean, you had the option to do that. I understand you think that you shouldn't have had the phase 2 and that was wrong in the first place. But at least on the facts, you had the option to put in additional evidence.
Well, it was not our burden to put that evidence on because
Well, it may not be the burden to put it on, but in defending against what you were defending against, it might have been pertinent.
Well, Your Honor, we had already been told by the trial court that Steves was going to rule the day and that the only focus was going to be on our client's intent. So we did not see why we would put in any evidence from the insurer.
So that was your choice, but are you not necessary, if we decide, my point being that simply there was additional evidence that one could have put in to have defeated it on the facts instead of the law.
There could have been, but the jury still would have been instructed incorrectly under the law.
Was the jury instructed as to the different elements of the workers' compensation settlement?
The jury was instructed to determine whether the settlement documents showed that my client intended to release the tort defendants. It
Right.
was never asked whether the workers' comp insurer intended to do that.
When it came to the second question about full compensation, was the jury instructed as to what workers' compensation benefits are intended to compensate for under the statute?
I don't believe that they were, Your Honor, no.
Okay.
Well, assuming that the argument really requires us to overrule Steve's, stare decisis has a certain weight, and so one of the things we look at is this aberrant? Is this an outlier? What do other jurisdictions do as to this specific issue? Can you give us any insight as to that? Is this the requirements of what you have to prove under Steve's? Is that, because I've looked at treatises and I'm not seeing anything that says this is an aberrant outlier.
Well, I think, number one, Steve's is aberrant because the law in Maine on determining whether a party is a third-party beneficiary.
Well, but Steve's wasn't based on a third-party beneficiary analysis. That wasn't the reasoning. And nothing has changed in the law on third-party beneficiaries since Steve's was decided. So it was based on this, they treated it like it was the common law joint tortfeasor release. You release one and everybody gets released. And at the time, the Steve's decision was considered fairly liberal because it said, but we don't want to use that because that's too harsh. So we're going to say, no, you can prove that it shouldn't be a release if you can show the intent of the employee or not full compensation. So why is that so unreasonable?
Well, I think that the changes in the Workers' Compensation Act since Steve's was decided matter a great deal.
How do they change the reasoning being no longer good?
Well, for example, Your Honor, now that in 1969, 2 years after Steve's, when the Compensation Act was changed so that employees got the first bite at the apple pursuing a tortfeasor instead of employers.
Was there a lien in Steve's versus Irwin? Would there have been a lien at that point? It appears to me in Steve's versus Irwin that there was not a lien.
Under Steve's v. Irwin, the employer had the right to pursue.
Right, but they indicated that they weren't going to, right?
Correct.
So is that a difference between Steve's and where we are now, that now the employer has an automatic lien and in Steve's it did not, and therefore who is intending to release is a different analysis. In other words, that we can't just depend on the employees.
That's correct, Your Honor. And this court, even in Connell v. Aetna Life and Casualty Company, specifically said that the rights of the claimant and the carrier, workers' comp carriers, are created by statutes embodying legislative purposes that may not be disregarded. And therefore, a comp carrier does not relinquish its statutory right to a lien unless it expressly agrees to do so. So I think that the change in who is entitled to a lien and the statutory right to a lien does change the
But
analysis.
you
Well,
agree
Steve's
it's possible that they could have released it. It could be the intent at the time of the settlement, even today, to release it.
It could
to
be, Your
release
Honor,
the
but it
third
needs to be
party's
clear
tort.
and definite, and even in that case I just cited, Connell v. Aetna Life Insurance, it needs to be express.
Well, Steve's even applicable to this case? Who's the joint tortfeasor who was released?
The joint tortfeasor would, I guess under the ruling in Steve's, would have to be the employer, but
But did the employer commit the tort in this circumstance?
the employer did not, no.
So,
But I believe it was...
Steve's used the language original tortfeasor or obligor, which would be an employer.
Right.
So what is so unreasonable about the condition and about intent? And we have a jury that said the intent was to release. So why is this an inequitable result that requires us to overrule precedent?
Well, the jury found that there was an intent to release, a statutorily granted lien without considering whether the person who that lien goes to intended for that to happen, the comp carrier. I think that's the inequitable part.
And your client testified that he didn't intend to release it?
That's correct.
So what, this is probably a little off topic. How do you think the jury got to where they got based upon the four corners of the evidence here?
Well, I think that the jury was considering the evidence of the intent at the same time they were considering the collateral source evidence of how much he received in his comp settlement.
They got told he already got $190,000. We thought it was only worth $180 case over.
Yes.
If we were to agree with you and remand for a revisitation of the third-party beneficiary issue, would the new trial be just on Phase 2, or would it have to be from de novo on both Phase 1 and Phase 2?
We think it needs to be a total restart, Your Honor.
I thought you were agreeing that the Phase 1 could stand.
I think that's our
Fallback?
fallback, obviously, and Eppley's fallback, I think. But I think that the way that Steve's required this two-phase trial changed a lot of strategy and a lot of, I think it gave the defendant Eppley's an unfair prejudicial advantage, knowing that the jury was going to hear how much this guy got compensated in the second phase. And defense counsel was able to even tell the jury in closing argument, you know, I'm just putting this out there, but I think $180,000 might be fair. You know, that's up to you.
Is there any reason why the amount should have come in either under Phase 1 or Phase 2?
No.
Actually, shouldn't the amount have been kept out as a result of the change in the Maine Health Security Act?
Oh, I mean, I believe so. I think that there's lots of reasons it should have been kept out.
Well, the reason that you're here, though, is because you've got a release that was rather broadly written and that it's confusing and ambiguous. So do you have any disagreement with the fact that this became a fact matter to be determined by a jury?
No, I think it's a matter of law still, because while the trial court was simply looking at ambiguity, but this court has found in third-party beneficiary cases, let's say in F.O. Bailey v. Ledgewood, it said that it held that the language of the contract did not generate a fact issue as to a clear intent to create an enforceable right as an intended beneficiary. So it's more than ambiguity in a third-party beneficiary situation. It has to be unambiguous that there is a clear intent to create a third-party beneficiary.
Thank you.
Thank you, Your Honors.
Mr. Gould,
Thank you, Your Honor.
and I note that right off the bat, you didn't reserve any time.
I did not. I am ready for anything you might, well, I hope I'm ready
so
for anything.
under Steve's, Steve's posited two ways, two parts, and in Phase 2 of this trial, essentially you prevailed on both, i.e. that it was the intent to release the tortfeasor, but also that the compensation received under the Workers' Compensation Act was full compensation, right?
That's correct, Your Honor.
So here's my question. If the employer has a lien by law under the Workers' Compensation Act, put aside the first part, just going on the second part as to if you can get out of paying anything upon a jury determination that it was full compensation, without regard to whether it was released or not, doesn't that completely undercut and go contrary to the automatic lien under the Workers' Compensation statute?
I don't believe so, Your Honor. I mean, first of all, when negotiating a workers' compensation lump sum settlement, whether or not the employer and insurer wants to waive the lien is a matter of negotiation.
It can be, certainly. Right. But if we accept under Steve's that the doctor, in this case, would be automatically released if a jury found that the amount received in the workers' compensation settlement was considered full compensation without regard to whether the employer waived or was asserting their lien, isn't that the problem?
I don't believe so, Your Honor, because, again, you have to go back. You can't look at the case from the perspective of events after the settlement. You have to take a look at the events leading up to the settlement and the settlement itself.
And I'm trying to separate that.
Okay.
What I'm saying is, if we accept what Steves says, then in a case, let's take a case where the release was different. There was no question that there was no third-party tortfeasor that was being released. The third-party tortfeasor was not being released, okay? And the employer is maybe even actively, maybe the employer even brought the third-party case, okay? They're actively asserting their lien. If we follow Steves to its conclusion, then you would be entitled to say the amount that the employee received in their workers' comp settlement is sufficient to compensate. So even though there's a lien, and even though there's no release of the third-party tortfeasor, we get out of it.
Well, the problem with that, Your Honor, is I think there are a lot of links in the chain that you have to go through before you get to that point in time. First of all...
Well, isn't that what Steve says, though?
Well, let's also remember that Steves was decided on summary judgment, and that there was no factual background laid before the court, which the court could consider in deciding these two issues on appeal. Let's say post-Steves, okay? The employer and insurer, with knowledge of the standard that Steves has now imposed upon the parties, that may motivate the employer and insurer to be more active in pursuing their third-party rights. They could themselves go out and seek reimbursement from a third-party tortfeasor.
Let's assume that's what had happened here. Let's assume it really, there was no such release that could be construed as releasing the tortfeasor, and assuming this was a subrogated right, the employer was asserting their lien and bringing the third-party claim here. Under Steves, weren't you, I think if I'm following your argument, you were still entitled to put in the second question, i.e. whether the compensation received in the comp case was full compensation.
Right.
Doesn't that completely negate the statutory lien?
Well, it doesn't, because that's a factual determination to be played out by a fact finder prior to getting to that point in time where the court has to make a decision.
Same facts. Jury says it was $180,000 of pain and suffering, and oh boy, he received $190,000 in his workers' comp settlement. That seems like full compensation to me.
Well, let's also remember that the benefits received by Mr. Greenwood from the workers' compensation insurer was more than the $190,000.
Because there were probably weekly benefits and
Exactly.
medical benefits.
Exactly.
But the jury verdict in this case was only, was very specifically limited, and in fact, the request was specifically limited to the damages for pain, suffering, loss of enjoyment of life, and permanent injury. Now, permanent injury is compensable under the Workers' Comp Act, but pain, suffering, and loss of enjoyment of life are not.
They are not. But let's, again, take a look at the facts at the time of the settlement. If you look at the findings of fact entered by the administrative law judge, there were findings for future medical expenses and a specific $19,000 set aside. And there was also a calculation by the administrative law judge for lost earnings going forward for Mr.
And there was no amount sought for earnings in this case or future expenses, correct?
That's absolutely correct. So what the facts tell us is that at least part of that $190,000 settlement compensated Mr. Greenwood for elements that would be compensable under the Workers' Compensation Act that he never incurred. So the compensation that he received as a result of the settlement was greater than he would have received had he not waived his rights to receive workers' compensation benefits. Because there were no lost earnings going forward after the settlement, and there were no medical expenses.
I'm sorry, I just really did not follow that argument. I'm sure I wasn't.
No, I will try to do better, Your Honor. There was a finding of fact that and I'll just focus on the lost earnings. There's a finding of fact by the administrative law judge that the settlement essentially equated to 400 some odd dollars, I think, per week for the rest of Mr. Greenwood's life expectancy as compensation, representing compensation for lost earnings. We know, in fact...
Lost future earnings.
Lost future earnings, that's right. We know, in fact, that he never incurred that loss because there were no lost earnings, or at least no lost earnings that were ever presented to the jury for consideration. So
But that doesn't mean they weren't incurred. That just may mean that, again, depending on how the lien folds out, that if no lost earnings are presented or other wage things, in other words, if the only damages that are presented, although there is some overlap, is for the kinds of damages that are not compensable under the Workers' Comp Act, then, as between the employee and the employer may not end up leaning the entire amount of the recovery.
Right, and maybe where I was a little unclear, Your Honor, is that the point that I was trying to make is that if, in fact, Mr. Greenwood never incurred future lost earnings, then at least some portion of that $190,000 lump sum settlement compensated him for something that he did not for a loss that he did not wind up incurring.
I'd like to ask a question that relates to what I asked the appellant, which is, again, my understanding is the basis of the reasoning in Steves was, let's be more generous than the common law rule on joint tortfeasors, because these really aren't joint tortfeasors. The employer is not a tortfeasor. So, and now we're looking at, should Steves be dismissed under rules of stare decisis because something has changed that would undermine that reasoning. And I'm wondering whether what would undermine that reasoning relating to joint tortfeasors is in 1969, they enacted a statute that got rid of that common law rule about joint tortfeasors and said it's not automatic. And then it had a process for how you deal with that involves after the trial, you figure out the set-off. So why wouldn't that be a basis to say the world has changed since Steves?
Well, what I would argue, Your Honor, is that the scope of this particular case here, this Greenwood case, is very, very limited, okay? This does not invoke broad policy considerations. What this case involves is the interpretation of a release signed by Mr. Greenwood and an agreement between the parties, and the interpretation of the language of the lease. And this court, whatever this court decides to do with this case, is limited to the specific factual...
But if we were just looking at regular old contract rules, then wouldn't their arguments about third-party beneficiaries resonate? Because we wouldn't ordinarily read into this if we were just deciding, did they really mean to this, to release this person? It would be unlikely, wouldn't it?
Well, not necessarily, but I think more importantly, Your Honor, is that that issue's been waived because Mr. Greenwood never submitted a jury instruction, never asked the court to instruct the jury in accordance with Section 302. In fact, while reserving all of the arguments that they made that this issue should not at all go to the jury, the plaintiffs did not object to the court's instruction on Phase 2.
Putting that aside, is Steves consistent with Section 302?
At its heart, I believe it is, Your Honor.
How so?
Because essentially what Steves is talking about is the intent of the parties. And if you look at Section 302, Section 302 specifically says, and I don't want to misquote.
But in this case, wasn't the jury directed to look at the intent of the promisor as opposed to the parties? And
I'm
isn't
sorry?
that a problem as opposed to the parties? And isn't that a problem under the analysis that's appropriate under 302?
Well, I don't think so, but before I get to that, again, I want to raise the issue that the Section 302 jury instruction was never requested.
Well,
If
doesn't
it
the
was
court have an
requested-
obligation to instruct the jury as the correct law that applies to the case? And doesn't Warner change that world since Steve's?
Well, I've got plenty to say on the collateral source issue. But to address your specific concern, Section 302 specifically talks about the circumstances and whether or not they indicate whether or not the promisee intends to give the beneficiary the benefit of the promised performance. And what the jury had here in this case was the plain language of the release itself, which, if you look at the language that relates to third parties other than the employer and the employee and the insurance company, specifically talks about any other person potentially responsible for any injury suffered by the employee during his employment, which this injury was.
Can the employee release the employer's statutory lien alone?
Well, I'm going to bring up Butters versus Kane, Your Honor, because under Butters, and that's old law too, but it's still good law. Under Butters versus Kane, if two parties enter a release, unless specific rights are reserved within the language of the release, that's treated as a general release to both parties.
But there's no statutory lien there. I don't believe
know.
in Butters versus Kane.
Well, I agree with you, but
Okay,
I don't
so that's
know.
my question, is given the statutory lien, it seems to me, I mean, it just seems to me that an employee can't unilaterally release the employer's lien. And if that's true, then don't we have to, whether or not it was requested, don't we have to say you have to look at the intent on the release of both parties? And that even if that was not requested, doesn't that become obvious error? Because otherwise, we're saying the employee can unilaterally release the employer's statutory lien if that happens to be the employee's intent.
Well, no, I don't think we need to go there, because even if you look at all of the case law that's been cited here relating to third-party beneficiaries, it specifically talks about the intent of the parties, which may be derived from the documents themselves. And that's where the jury, in this case, can derive the intent of the insurance company. That the
But were they instructed that they had to determine that it was the intent of the insurance company as well, or only the intent of the employee?
The jury instruction, not objected to by Mr. Greenwood, related only to Mr. Greenwood's.
And so my question had to do with, isn't it obvious error if, in fact, by following that to its logical conclusion, the employee then can unilaterally release the employer's lien?
Well, again, I would disagree with that, Your Honor, because the jury can derive the employer's intent from the language of the release itself.
Wouldn't that lien be inconsistent with the policies behind the Workers' Compensation Act, though?
Well, again, it's up to the employer and insurer whether or not they want to waive the lien, which happens.
They hadn't done that in this case, though.
Well, there's no evidence of that one way or the other than the language in the release. Thank you.
Thank you, counsel. Mr. King?
Your Honors, I think first to Appellee's argument that the Section 302 argument was somehow waived, I just want to point the court to at least in several of the trial court, opposition to motions for summary judgment, motions in limine, the appellant argued that Section 302 should apply, and actually after the final verdict in Phase 2, before plaintiff's counsel was about to relist all of their objections, the trial court just said, all the arguments that everyone's made throughout this case I consider preserved. So I don't think that a waiver is probably the right word for that.
But counsel, I mean, do you agree that on its face, the release at least, I mean, it does seem to release tortfeasors on its face, correct?
The release itself,
I understand all your arguments that there's other documents involved, that it has to be approved by the Workers' Compensation Board, et cetera. But on its face, just looking at the release, it's certainly at least one interpretation is that it released everybody and all damages.
I would say that one interpretation
Okay.
does not make a clear and definite intent.
Well, if we decide that there is at least a fact question on that issue, don't we have to, but if we agree that at least the employer's intent also has to be considered, is that essentially a new trial on phase 2 with perhaps different parameters?
I think that there's still problems because of decisions that were made in phase 1, knowing what was coming in phase 2.
Can you specify what you
Yeah.
mean there?
I specifically mean the defense counsel was able to have a target number to offer the jury that it knew was lower than the settlement amount they were going to hear about in phase 2. I think that is something that would not have been allowed, or would not have happened if that settlement amount was not going to come in later on in the case. And then there were also, I think just knowing that.
But I guess what I'm not following, are you saying that as a matter of law, that on summary judgment, one cannot interpret that release as releasing the tortfeasor?
On summary judgment,
If you apply that standard.
I would say that as a matter of law, let me think about this. So the jury, I think if the jury had been properly instructed and it had made the same decision, if it had been instructed to consider the intent of both parties.
Okay, so I think what you're saying is you agree that there may at least be a fact question on the intent of the release. It may not have been instructed correctly or given the correct parameters, but there is at least a fact question that will have to be determined.
I still believe, I disagree that there's a fact question as to the ambiguity of the contract, but I think that there's not a clear and definite intent.
Okay, thank you.
Thank you, Your Honors.
Thank you, counsel, for the argument here today. As is our usual practice, we're going to take the matter under advisement. You'll get a written decision in due course. But as is also our usual practice, I understand, Mr. King, that this is your first argument in front of this court, and we would ask counsel to come back and take the greetings of the court.
Thank you.